And welcome to the Business Reboot Toolkit, a mini-series to give dental practice owners ideas on how to effectively help their talents grow their business in the current climate. So joining us today is our speaker of this series, Yasmine Healy. She's the founder and head lawyer at Clinton Legal, and Yasmine established her business in response to the introduction of the Fair Works Act to help employers understand and utilise the law to help their practice meet their goals. So 95% of Yasmine's clients are dental and orthodontic practices, and they're based all over Australia. So welcome to the show, Yasmine. I'm so excited to have you on today. We do have a lot to cover, so it's really great to have you here.
Thanks, Becky. It's great to be part of this. I've got quite a few people on your Facebook group who I'm already interacting with. So it's really good, I think, to have a forum where people can come together, share information and resources, especially on these very important topics of employment law and HR for dental practices. So thanks for having me.
No, thank you. It's great to have you. So Yasmine, can you just start off with, I suppose, giving everyone a bit of a background about how you broke into the market of dental and why 95% of the businesses that you serve is dental or orthodontic practices?
Yeah, I'd love to. So I'll just give you a bit of a summary of, I suppose, my background and story. I'm a legal practitioner, obviously, and I worked in-house, and I really enjoyed that path of, say, general counsel, company secretary for, say, the first 10 years of my career. During that time, I married someone who was a dentist and became an orthodontist. So that, I suppose, started my exposure to the dental and the ortho industries. So alongside with my professional career, I was always, I suppose, playing a role in establishing, building, growing the practice, not just for our own family business, but also for a lot of colleagues and friends and family members too. And then we had the introduction of the Fair Work Act in 2009. And just after that time, I noticed that a lot of employers, people that own practices, were asking me the same questions. So they were asking me, about issues with their employees, how to manage them. And it seemed like the Fair Work Act, to me anyway, was quite supportive and favourable towards employees. So I just wanted to make sure that there was a resource, some advice out there to employers as well. And because of my industry knowledge, it just evolved really organically that I developed and put together an online product of employment law resources and materials. I was just repeating myself with all the advice I was giving to people. So I put together all of these resources and then licensed them out to various practices. And that's how it began. I took it to market, I think, in 2014 on the basis of the documents and the package information. Before that time, I was just providing one-on-one legal advice, and then it just grew. I realized that there's just such a huge demand out there, especially for small businesses. It's a really tricky landscape, and so it's just great to have someone on your side who's got your back when you're faced with an issue from an employee. So that's kind of the story of how it developed, and because of my industry knowledge in dental and ortho, that's why I'm really focusing on those areas. Most practices are small businesses, and I have expanded to medical practices too. But I'm really enjoying it. I mean, I understand and get what it's like when you're dealing with staff issues in a practice. And so I just love to be able to help. So that's, I suppose, the reason why I developed Clinton Legal. It's the reason why I've specialised in the industry rather than just being a lawyer generally, just dental, ortho and medical. And that brings me to where I am now. So I hope that explains it.
Yeah, that's fantastic, because I think, a lot of dentists would really appreciate the fact that, the person that they're working with has the legal background, but also understand the dental side of things, which, it can be a bit unique, compared to other types of businesses, can't it?
It is definitely unique. And I know, like, I'm being involved in the practice, that if I'm trying to explain an issue, it might not be legal, but say a commercial issue, to someone who doesn't get the practice, I might be talking about, I don't know, an imaging machine or something to do with steri, that if you have to explain it from A to Z, it's just going to take so much time. So dealing with someone who just gets that, has that corporate knowledge, and also someone who works with you, like with my clients, I like to have a long-term relationship with them. So I get their practice, know what their goals are. It just means that when I provide legal advice, it can be much more strategic and take into account the corporate knowledge as well. So I agree with you. It's really good to be talking to someone who knows the industry.
That's fantastic, isn't it? I didn't realise that the Fair Works Act came in only so recently. I always thought Fair Works was there a long time ago. What was there beforehand?
Before that, we had work choices, dare I say it, and I say it like that because it wasn't very popular under the Liberal government. So yeah, Fair Work Act came into place in 2009, and it really revolutionised the industrial relations system. It also came under that national umbrella, which is what we have now. So everyone's covered, other than like a couple of public organisations and some employers in Western Australia. So it's a really different system, and a lot of employers would have the view that it does, I suppose, favour employees. That is arguable, but at the end of the day, just to know that there's a resource available that is there for the employer, I think just gives peace of mind. So yeah, 2009, and it's really changed the whole system. And what we see now with the government after all this stuff with COVID is that there is probably going to be another massive overhaul again. So from my point of view, to be around and to be helping with the work choices, or during the time of work choices, I should say, and then during the time of Fair Work Act, COVID, and now under this new, with all these new changes, it's really exciting, because sometimes you might have someone that's been with you for 15 years. And so when you need to work out what their long service leave entitlements are, or if they're entitled to a redundancy payment, you can't just look at the relevant legislation. You do need to consider what award applied at the time that they started, what state are they in. So you do get complex questions. And in that time, it's good to have someone who's been around or working in the various times, in the various stages of change.
So is employment law, especially in dentistry, is it different from state to state, or like are there little variations in there? Or
That's a good question. So before the Fair Work Act, yes, it was. So if you're employed or someone was employed before 2009, it would still arguably have some different rights and obligations. But it was standardised. The one piece, or the main instrument is the Health Professionals and Support Services Award, which I'm sure everyone listening to this would be familiar with. And that is actually national, except for a couple of people in Western Australia that sit outside the system, or a couple of public organisations or entities. But 95% of dental practices who have dental assistants will be covered by that award. So it is national in its application. In addition to that award, the Health Professional Support Services Award, we also have the national employment standards that apply to all employees in your organisation as well. And then you're going to have your employment contract, hopefully, if you have one. And then there's also going to be some other types of legislation that apply as well, such as workplace health and safety legislation, anti-discrimination legislation, and they're all the legal instruments that employers need to know to be able to follow the law when they're managing or dealing with employees in a dental practice.
Wonderful. There's a lot there, isn't there?
There is, and it's quite a complicated, even within the award itself, as you know, and I'm sure others listening to this know, like to understand the award and the different rules for part-timers, full-timers, all the entitlements and allowances, it can just give people a headache. And a lot of my clients might not even might not know the award, might not be following it, and then it causes issues. So yeah, it's really important whoever owns the business, or the practice manager who takes care of HR, does read and understand and have a good working knowledge of the ins and outs of the award at the minimum.
Beautiful. So Yasmin, I'm just wondering, there are rumours at the moment that's up and coming. People are talking about changes in the HR sector potentially, and so they're talking about things like casual, in terms of casual workers, in terms of, I think there are rumours, although we just sort of clarified a little bit more, people were saying that there might be some leave entitlement changes as well that's already implemented for part-timers. And yeah, can you just run through what are some of the possible changes that might be up and coming, and when we would potentially expect to see these changes get implemented?
Absolutely. And so first I might just speak to the personal leave changes that came into place actually a few months ago. And so there was a case where a person or a group of people, let's say, were working shift hours. And so they might work 12 hours over 3 days a week to make their full-time hours, or just over 12 hours, rather than say 7.6 hours a day. And they argued that, look, I need to take a day off for sick leave. I should be entitled to be paid 12 hours because that's what I normally work in that day, rather than 7.6 hours, which is how prior to that time personal leave had been calculated and taken. And in that case, the federal court agreed with the employees and said from now on, part-time employees, so this was a change for part-time employees, are now entitled to 10 days personal paid leave each year. And so are full-timers. They're also entitled to 10 days personal paid leave each year, but it goes based on the days you work. So if a part-timer works 4 hours, taking that 4 hours is 1 day of leave out of the 10. So that was a recent change that came into effect really months ago now. So that has already happened. And so in terms of what we're going to look forward to going forward, the government's indicated wanting to simplify the whole award system. So my interpretation of that means that hopefully the award is going to be simplified, the Health Professionals Support Services Award. Hopefully there's going to be the ability to, for example, have an annual salary agreement where, say, a dental assistant might be paid, say, 50 or 55,000 a year, which is all inclusive. And some awards outside of our industry have already actually got something like that in the award, but nothing in our award yet. And a lot of practices are already following that and finding that they get into trouble when they need to produce their records. So hopefully having some type of annualized salary agreement is something that we can look forward to. Another massive change, there was a recent case about casuals, and I'm sure a lot of people listening to this have heard about it. And the Federal Court found in 2 recent decisions, and they are binding decisions, that casuals who work regular, consistent hours and have an ongoing expectation of work are entitled to access paid leave, so annual leave and personal leave, for example. And that's really problematic because it means a lot of people have been paid the 25% loading, but then now they can have a back pay claim for paid leave as well. And in that case, actually, that's what happened. So the employer said, hang on, they've been getting the 25% loading. So if that person isn't a casual because of their regular hours, but they really are permanent and should get leave, then can we please have that 25% back, or can that be reconciled and adjusted? And the court said no. So this is a massive decision that came out right at the time of COVID, which a lot of employers have found would be crippling. And so I think the government is going to address that as well. It looks like, based on the announcements it's made, it has to also be supportive not just to the employers, but obviously the unions and employees. I think they're going to put into place a rule that there is a right to convert to permanent role after, say, 6 months of casual work on a regular basis. But I think they will also address this 25% loading and double dipping issue as well. So I imagine that risk will hopefully be mitigated. But at the moment, that's obviously a massive concern for employers who are currently facing, wondering whether they're going to have to pay their casual employees for the leave as well.
Yes. Well, as you know, all businesses, but including dental practice owners, everyone's sort of bracing themselves for, whatever it is, the second wave recession or whatever. So I think everyone's going to be buckling up a lot when it comes to, expenditure. And this will just be the next thing that will just tip things over the edge, wouldn't it? It's just, imagine someone's run their whole practice on casual employees and so they're left with this sort of predicament. Yeah.
It's a massive concern. It really is, very scary for employers to be thinking about that. And with JobKeeper, as most practices are probably accessing JobKeeper, as you know, with JobKeeper, casuals can be entitled to the payment if they've been a regular, consistent employee. So in a way, you think, well, that has been put out there and practices have bent over backwards to meet that requirement. And now they've said this person is regular and they're a permanent person, even though they're working on a casual basis. So in a way, maybe that itself could be evidence of the type of arrangement. But I am hopeful that that will be a change that will help employers as a result of this new review that's happening for industrial relations. And that is that there'll be something in place to stop the double dip. So 25% and paid leave, you've got to choose between the two. Just quickly on casuals, hopefully a lot of you know that in the award at the moment, there actually is an obligation to advise your casuals after 12 months that they're entitled to request conversion to a permanent role, which can only be refused on reasonable grounds. So some of my clients, when they started with me, hadn't done that yet, hadn't told their casuals that you have a right to do this. And so if anyone listening to this hasn't done it, that's something that you'll need to do as soon as possible.
Okay, that's really good advice, actually. So are you saying that now, if you've never offered them the opportunity to go on to permanent, now is a good time to do that as well? Is that's what?
Yeah, I think there's two separate things. So the first issue is if you have a casual and they've been working casually, I suppose, and you haven't offered them an opportunity to request a conversion under the award, that you must do that. That's required right now. That was required before this case and this change in the decision. So that's one thing, and that's in order to comply. And then second to that is the question of what do you do with casual staff now that you know this could be an extra liability. And so I would say the test is going to be if they are a regular casual. So are they working, say, 20 hours every week, same hours, or even 35 hours, and are they going to expect that to continue? If it is possible to alter the hours, say your practice genuinely needs it, then it probably would be sensible to break that pattern if it's consistent with your business needs by changing the hours so they're not exactly the same start time, finish time, and they're not exactly the same every week. I do have a few clients who are covered by JobKeeper, and they have casuals that have been doing regular, consistent hours, and that's why they're covered by JobKeeper. But they have decided now to decrease and change the hours, and the employees are happy with the decision because it's reducing their hours, but they're still getting JobKeeper just to try and do some risk mitigation in the meantime. So that's something that's happening. That's how I would try, if it's possible and if it's genuine, to manage the casual employees if you want to keep them casual. On the other hand, there is the opportunity to speak to employees and to say to them, now you're casual and we'd like to offer you a permanent role. If someone agrees to that and they become permanent, then certainly you'd be mitigating the risk of the 25% plus the paid leave from the time that they become permanent. But that's not going to change, I suppose, the nature of the relationship before the time they became permanent. So that might only help to mitigate risk going forward rather than over the whole time of their employment.
So it's just mitigating that moving forward, basically.
Exactly. Yeah. That's all it would do effectively. Yeah, I mean, it's not, I think we will see more from Fair Work even before the results of the IR overhaul come out about casuals. So we haven't seen any communication from them yet. So there might be some clarification that they make or some further definition of the test of casuals. And certainly in our award that we operate, and I know the cases actually were in a different industry altogether. So the awards are different per industry, and some industries don't have awards. And so if there is an award that defines a casual, that might also be helpful. So our award does talk about what a casual is. And so if an employer is faced with, unfortunately a claim for back pay, there'll be new arguments that were different to the recent cases where we might say, well, look, this is a person who's a casual in accordance with the award and it's defined here. These facts are different from that case, so they should be distinguished. So that's when the legal argument comes into it. But bottom line is, yes, there is risk at the moment. I do think that it's going to be mitigated with the government changes, and it's good to think at the moment about, if you can, changing your casuals hours around a bit if it suits both parties, or thinking about mitigating risk going forward by converting to a permanent role.
That's certainly very, very good advice there. Thank you for that. I'm just thinking, at the moment with the current situation and, with the COVID-19, there's been a lot of changes in terms of, for employers in general. They might be like, okay, circumstances have changed for my business and I'm, looking at doing things differently. And there may be circumstances that come up where you want to negotiate with the employee to have a slightly different contract arrangement. How do you tread that carefully? Because I know oftentimes, I know everyone says they can't be worse off and all that sort of stuff. What's the best way to go around it? Because I know this is actually something a little bit special for you as well, in the sense that I know the services, just from me chatting to you, the services that you provide isn't purely just here's a contract, go and get it done. You're very much about guiding your clients in terms of, how to sort of, I suppose, come to some sort of buy-in or agreement on having this changed or having the variation happen.
Yeah, that's a really great question. And to consider and answer that question certainly requires more than just a legal assessment or a legal answer. And I think you can definitely give a better legal result if you take into account other factors as well, such as, on the HR side of things and aligning the team and all of those things like we've discussed and some of your members of your forum have already discussed with me too. So I think it always goes back to how you communicate the real issues with the employee. So it comes back to communication, it comes back with consultation, and you want to do it in a way where you're honest and genuine by explaining the needs required for your practice, but you also want to point out the benefits to them and you want to try and make it a win-win solution. So in the case where you might have an employee and you want to offer them a different contract, you need to understand, well, why would they be incentivized to agree to this? So the first thing to think about is what would be interesting to them. And you need to really emphasize that. So I would firstly meet with them and say to them, and this is not even taking into account the legal obligations because they are run alongside it, but they kind of complement each other, I suppose. So you want to do it in a way that takes into account the legal and the, I suppose, HR side of it. So I would meet with them. I would explain the situation of the practice to them. For example, we're going to need some more flexibility. This is the impact that COVID's had on the practice. This is what we're going to be requesting of our team coming up. I'm just letting you know this because I feel like it's really important that you understand where we're coming from. I see you as a valuable long staff member, and I want you to understand, all the facts surrounding it. So if you give full information to them, they're going to understand where it's coming from. If you just say, we really need your flexibility and here's the contract, the question might go into their mind, why are they doing this? Is this just a means? Is there another purpose for it? Don't they like me? Did I do something wrong? So when you communicate with them, you're eliminating the doubt really from the beginning and making them see the true point of your request. And once you've communicated that, then I would start to try to show them the benefit to them in agreeing to it and suggesting at the end that that might be a win-win solution. So you will need to have something in the contract or something in the arrangement that they can see as positive and rewarding and that they can relate to. So if I think about it on an individual basis, because you might have a different strategy per employee, you might have some employees that might want to slightly change their hours for another reason. Some employees want a particular day off. Some employees are motivated by money. So you have to know the currency of your employee to be able to relate to them. And you really need to, I suppose, follow that consultation communication process and disclose the reasons to them without disclosing anything confidential, and make sure it doesn't look like you're pushing them into the agreement either. So, you would ask the question, do you have any questions about this? Do you understand where I'm coming from? Does that make sense in relation to my business goals? Do you think it's something that you could consider in our arrangement? Is there anything we can do in our arrangement to make it better for you? So I'd be asking questions. So when they answer you, you've got a clear understanding of, or a clearer understanding of what their view is on the situation. And the best result would be if they actually said, well, how about this as a suggestion? Why don't I change this day to that day? That would help you out. So, you could try and take them to that point and see if they can come up with the solution that you want. That's the ideal way to do it. And that doesn't just involve one conversation. I know, Becky, that you're a fan of this and I agree with it too, that you do have to invest at the beginning of setting a good culture, one where people feel psychologically safe. They're not operating under a fear of or threat. They're operating in an environment where they feel safe, where it feels good. And I think people are more likely to give you the benefit of the doubt, try and agree and try and cooperate in those situations. Most of my clients through COVID, we haven't had to stand them down under JobKeeper enabling direction at all. So most of them have actually agreed to leave without pay, or they've offered to change their arrangements temporarily to meet the business needs. And that was by showing them in their time of need, we were there. Our goal is that you're going to have employment through this. We're going to do this to ensure that your role is safe, but this is what we need from you. And, to communicate with them, look what's happening, the cost of PPE now. It used to be, say, masks was $500 a month. Now it's $6,500. That's what we're facing. We're struggling with that. So it's making sure you communicate what your problems are. Try to give them something in return for their cooperation. Communicate in a way where they feel valued and respected. Like you're sharing this information with them because you value them and want them to feel like they're part of the decision. So I would even say that to them. So look, at the end of the day, it's like all things comes down to good communication. It's also important though to know in the back of your mind, clearly have in your mind, what are your goals? And is there a backup process that you need to follow if this doesn't work? And so that's where it's good to understand the legal side of it as well. And then I would see if you can bring them to make the suggestion. And yeah, I suppose it's just a process of doing that. And if you maintain that type of open relationship with your staff over a period of time, it builds up trust. And then when things do go wrong, whether it's you needing their flexibility or you being in a position to give them flexibility, because it's not going to hurt you too much to do that, then you do that. And that's, that's how I would, I suppose, achieve that. So a bit of a different approach. It's not just, here's the document, sign it. You need that to be done. But how do you do that? You have to put effort in, and you have to be strategic, and you have to understand their currency as well. So that's my opinion on it, and that seems to be effective in terms of the clients that I help.
Yeah, certainly. And I think that certainly worked even within my own practice as well. That's really good advice. It's just a whole string of pearl of wisdom there. So that's great.
Yeah.
So I guess the other thing that I sort of want to touch on today is talking about contracts and also employee handbooks. And I know for many people, contracts is a very familiar sort of thing. Can you explain what the differences are? What's an employee handbook? What's a contract? What's the difference? When do you use them? And I suppose the other question is, how often should we be, well, do we definitely need them? And how often should we be updating these things?
They're good questions too. Yeah. Well, in my view, I think there are some foundation things you need in place for any practice. And I think a staff manual or an employee handbook, as well as written employment contracts, are two of those crucial things. So they're things that you can refer to easily if a problem arises. They regulate and clarify the whole relationship, your contract as well as your employee manual. So my view is that they're both essential items. There's a couple of things which are essential, and I think both of those are. So the first thing we do with my new clients is make sure we put those in place. So I think the employee handbook, or the staff manual as I call it, normally contains the foundation policies. So they're things that it's very important and you shouldn't miss having in place, like code of conduct, bullying, complaints, also very importantly, your values and your mission, because separate to all this compliance stuff, having your values, I suppose, articulated and communicated to your team is a really important reference tool. And then you can align your employees and make sure they perform by adhering to those values throughout their employment relationship. So there's various reasons why it's important to have a staff manual in place, but the compliance, like I mentioned, with foundation policies, and also to articulate the history and your values. And then separate to that, your contracts, that's more of an individual relationship with the employee. So staff manual applies to everyone and the practice as a whole. The contract is a document that's individual between the employer and the employee, but that should include everything that regulates the relationship. And it should also, very importantly, the other I suppose foundation document is a position description that might be in the contract or attached to it. But it's very important, like if you employ a dental assistant, they need to know what your expectations are, or even a receptionist. So say someone's having trouble with the software and they're just not getting it, or they're not able to multitask, you're going to become frustrated over a period of time, not trust them to be by themselves on reception. But if it's clear in their contract, and then you can meet with them and refer to their contract and refer to your the values in the staff manual and say, it is an expectation that you can do A, B, C, D, and E, and we expect you to do this. How can we support you to do that? So you can refer to them. If you don't have those in place, then you're just essentially starting with a verbal chat of, I would like you to do this. And then they might have a response back to it. So I think they're very key to have the position description, the staff manual, and your employment contracts in place. And in terms of how often you should review them, hopefully everyone is doing regular performance reviews with their employees, like at least once a year. And that's for a more formal one. But I would also suggest like 3 monthly catch-ups for like 10, 15 minutes, just to say, how's it going? You know, at the last performance review, we thought we might try and improve or try to further train in this area. How's that going? So you're touching base and catching up with the manager. And so I think when you diarise those reviews, at least annually, you should also review the employment contract, because one, the award might require the pay to be increased after a year of full-time work. And so you don't want to miss that. And two, they just need feedback to be able to progress and feel like a belonging within your practice anyway. So it's good to review it and see if there's any adjustments. They might have taken on an expanded role, so it might be appropriate to acknowledge them for that and expand their PD and their contract for that. So they're just a couple of reasons why you would try and do them at least yearly. The other important time is when the law changes. So like with our members, I'll email people when there's an update to the law. So if your contract refers to an old rule, such as let's say that redundancy is payable if you've only got 5 employees, and you don't change your contract, then there might be an argument from the employee, well, it doesn't matter what Fair Work says, you promised me you'd give it to me. So, you know, you don't want to have something old in the contract, especially when it disadvantages you. So when the law changes, is to answer the question, I think you need to update your contracts at that time too.
Oh, that's really good advice.
Yeah.
Yeah. Excellent. So, well, I guess, what I'm sure you've seen lots of people make mistakes throughout, like just including whatever it is into their contracts or their handbooks. What are some of the most common, or if you had to name, say, one or two biggest mistakes that you tend to see, like really common things that people do? What should we be looking out for where we need to be like, okay, we need to be on top of this, go back and review it and change these things in our contracts?
I think just generally, in terms of prevention of so many issues, having those foundation documents in place, like proper contracts, the staff manual with the relevant policies, that's just going to, and position description is just going to make everything so much easier and avoid situations arising. So I suppose that's one of them, but I've already spoken about that. A very common issue specifically with a lot of my clients is that they'll contact me and I'll find out that they've got part-time employees covered by the award, but they're averaging or changing their hours. So it might be that the contract doesn't say for the part-time, this is the start time and the end time. It might say this part-timer works up to 30 hours a week, or it might mean that they don't even have a contract at all, actually. So one common mistake is people not realizing that under the award, if the employee works more than their agreed part-time number of hours, that they're actually entitled to be paid overtime. So there's been a lot of cases where people have found out, oh, now I have to pay them overtime, and they're a part-timer. So that's a really key one that comes to mind right away. So
you can't have a range when they're on. You can't have a range of hours that they're on for a part-time contract. It has to be dead set that many hours.
It can, what I like to do, because you normally need to say the start time and the end time, there can be flexibility if it's regular. For example, 1 week 30 hours, the next week 25, the next week 30, the next week 25. That's clear enough that it's determined. So, but what I like to do to just give a little bit of extra flexibility, which is still acceptable, is might say open till close. So rather than say 8 a.m. till 5 p.m., I might say open, and then if the roster is required them to start at 7:30, then that's 7:30. So the award does require you to say for your part-timers the days and the start time and the end time, but I read that to mean that the start time can be open and the close can be the end. So there's a very small amount of flexibility, but you can't average hours like you can for full-timers. So full-timers, you can average over the 152. You can't do that for part-timers. So that's a really common issue, that clients often bring. Yeah.
Yes. I'm trying to think now of my own contracts. I wonder if I've got something like that lurking around somewhere. But that's
it's pretty common, I think. Yeah, another really important one to mention, a really, really common one, maybe it's just because that's when people come to me, is that people are making decisions based on emotional reasons. So as a small business, say if someone's taking time off when they're not entitled to or they shouldn't be, people get really annoyed, letting the team down. We've invested in you and you're doing this in return. So people will often just be angry and want to and respond negatively to that person. And then it gets worse, which is understandable. But I think responding emotionally to a problematic employee is really going to generally lead to problems, because then it looks like there's a link between what they've done and your reaction. And as you know, for adverse action, unfair dismissal, it's getting into murky areas there. So if someone has a view that eventually I'd like this person to go, and if part of their decision is, something's upsetting them, then that could be held against them if it's like, a dismissal or a sickness or potentially discrimination. So I almost say to my clients, I understand that is annoying you, but that's the time to have a record of you being extra supportive and extra understanding. At the right time later, we could talk about the other issue. So you want to create a gap so there's no link between the two. And if anything, I always think, what would happen if this was put before Fair Work or a court? So all your correspondence, you need to consider, if this was read by a third party, what would they think? And write it in a way that the third party would think you're a wonderful and supportive employer. That doesn't reduce your options for what you can do at the right time necessarily, but it does make life easier if an issue arises. So I suppose a very common one is people reacting emotionally from something small to something big. So, yeah.
Absolutely. There's a time and a place for everything, isn't it?
Exactly. And it's hard when you're in it. Like I know myself as an employer, that when you're in something, you can't see the label if you're in the jar, so to speak. So if you have, someone independent looking at it, it's just so much easier. And I think just running your own business as a small business, like a lot of dentists are, it can be lonely there because you're not going to share these problems with your employees. So it is so useful to be able to talk to other practice owners and have some type of way to support each other. Otherwise, you're just in a vacuum and it's difficult to like be totally objective about your decisions.
Yeah, absolutely. That's why that support system is so important, isn't it?
Totally agree. Yeah.
So if, okay, I'm now thinking hypothetically, I'm pretty sure there are practices out there where people actually have not had any sort of, it's just been a gentleman's handshake and they've onboarded the person. There's been no contracts. How do you introduce a contract into your business for, you know, the people working with you, be it an employee or even an SFA, for example? Because I do know, I've definitely heard of practice owners almost being held hostage in some ways because they're so scared because they suddenly realize, oh my goodness, I had no contract. I really need this person to now sign one so that I won't get in trouble. What does that mean for these people?
It can be difficult, and I think generally if you have a really good workplace culture, it's much easier to introduce change. So if you have understood how valuable it is to put that into place, it's going to help at times like that. If you've got a relationship of trust and confidence, if the person doesn't think you're just trying to screw me and to get as much out of me as possible. So first, having a great workplace culture, if possible, is going to avoid that. Secondly, to introduce something new, I would start broad and then weave the conversation down. So I wouldn't say like, we need to put you on an SFA because we don't want to be called an employer. Can you please sign it? So I would start broad, you know, what's the purpose for it? So I would say, look, over the next 4 weeks, we're really excited because we're going to be doing a review of the documents that we have in place. It's going to be good for the practice to do this, and this is the reason why. It's going to make a more positive experience. It's going to help with the patient interactions even because people are going to feel better. It's going to give people clarity about expectations. It's going to give structure. We want to take it to the next level. So I'd start really broad like that, and then I would say to everyone, so you're keeping them updated again, communicating, you know, these are the things that we're going to be looking at. And I wouldn't just say SFA or just your employment contract. I'll be saying things like what type of contracts we've got, people, you know, to make people feel secure in their roles. You know, can we improve our position descriptions? You know, what can we do to try to extend the duration of people's work so we don't have a high turnover? So I'd go like that. So every time you're explaining it, yeah, they can relate and see the benefit to it. And then I would continue with that. And then the next thing might be, as discussed last week, you know, we've reviewed this and we came to the conclusion that we could improve by having agreements in place in these areas. Something that I'd like to talk to you coming up is maybe proposing an SFA to you. The reason why it would help us is this. The reason why it would help you is that. So don't forget, there's got to be some benefit to them. And then I would catch up with them and have a very non-adversarial, relaxed discussion, but a proper one about it. So you're conscious of how you're communicating. Are you seeming stressed when you talk to them? Do you have good body language? Are you being fair to them by giving them the opportunity to read it, ask questions? I would say take it and have a read and let me know what you think. And then they might come back, oh, what does this mean? What does that mean? Give the proper time and attention to answering their queries and make them feel like they're valuable. The queries are valued as well. And you're happy to spend the time answering them. And then you come to that agreement together at the end. So I suppose to summarize, I would probably take a collaborative approach in bringing the person to agreeing to it. So it's not easy to just introduce it. Change is never going to be easily accepted by most people anyway, except those with a great mindset who like to adapt and like to be challenged, which should be very highly rewarded and recognized in the workplace. So I think, you know, taking a collaborative approach, consulting and explaining your reasoning behind it, I find most people will get it and they'll be on the same page if they feel that you value them enough to actually explain to them your rationale behind it. You obviously need to be careful. It can't be an unlawful rationale. But if it's on a commercial basis, you know, it should be possible to explain it to them.
Yeah. No, that's fantastic. And I think you are completely right. You know, sometimes in life, fast is slow and slow is fast. You really need to take that time and make sure that, you know, it's the right place, right time, and you've addressed all the different things before you get what you need and nut down on that.
Definitely. And for some employees, like their view of their annual leave or personal leave is like their car or their house. They feel like it's something they own. It's a balance in their bank account. So if you understand how they see it and you understand what that individual is like, then you're going to be much more likely to be able to relate and explain to them as well. So just doing a one-size-fits-all approach, I think, isn't the right way. You need to understand the individuals and to be able to relate to them in your discussions.
Yeah. Absolutely. That's really good there. So I'm going to move on to one last question. With regards to the COVID-19 at the moment, people are talking about a COVID-safe business. What does that mean from how do we become a COVID safe compliant business at the moment?
So I think we're really lucky in dental because probably in terms of the clinic anyway, everyone's already doing more than what would be required at a state-based level to comply with workplace health and safety, so that all the infection control protocol is just amazing. So this relates to areas outside the clinic. So there is a rule now, so every state has, and it's regulated by the relevant WorkSafe or Safe Work state body, are requiring businesses to now put in place steps to show that they're COVID safe. So the obligation for employers is to demonstrate they're taking all steps that are reasonable and practicable to protect the health and safety of their workers. So some states are saying specifically you need a plan, you need a separate COVID policy, and your staff need to be inducted and trained on it. And if we turn up to your workplace, you need to show it to us, and then that's fine. Other states are saying you need to do A, B, and C, and D. You need to show you've got social distancing. You need to show there's instructions to wash the hands or to use sanitizer on arrival. You need to show that your staff amenity areas are appropriately distanced. But they're not saying how to do that. So that every state has got its own rules on it, but generally speaking, it's involving social distancing. It's involving how you deal with staff if they're sick, like if they report a symptom that could be COVID, what do you do? And it also involves how you are communicating with and directing or instructing people to deal with things like hygiene, and that's outside of the clinic, obviously. So they're the new rules now. They're more stringent, obviously, than before COVID. And so I've suggested just to most of my clients to use a plan. Several states are saying you must have a plan. Other states aren't requiring a plan, but you still need to show what you're doing. So I think if someone turns up to the practice and wants to know, and in a lot of states they're doing spot checks and can close businesses down at the moment anyway. So I think if you say, well, here's the plan, we've done something, then that's a really effective and easy way to address the concern, rather than, oh, there's 5 things we've done, I'll show you through it. 1, here's the hand washing basin. 2, come and have a look at the staff amenity area. It's just easier to say, here it is. But like any policy, you can't just put a plan together and say it applies. So you need to, have a little staff training or a staff meeting, tell them why you need to put a plan in place, tell them exactly what the changes are, tell them from when it's going to come into effect, give them an opportunity to think about it, ask them to give you any feedback on it, and then ask, do they have any questions? If not, okay, from X date, it's put into place. So a few steps involved there, but to answer your question, you need to show the steps that you're taking. They need to be able to be demonstrated if a third party asks or if someone complains. And I think having a plan, or a written plan, is a really good way to do that. Yeah, so that's kind of new. They always had the workplace health and safety obligations, but now it's probably just taking it to a different level because of all the COVID safe requirements.
Oh, that's great. Yeah, definitely. I think a plan is definitely the way to go. I do remember when the COVID first hit, the plan was changing every week. So that was really interesting, but now we're coming back and I think things are becoming a bit more sort of stabilized. So I think moving forward, if we had that plan in place, it'll probably last us for quite some time without needing to.
And it's totally fine to change a plan as well. So it might be that you revise it. There's a new law, you have to change it. So that's totally fine. Just like it's fine to change a workplace policy if there's a new rule on social media or something else that's come out. So I think having a plan is your starting point, but you shouldn't be locked into You're never locked into following it word for word, in the sense that if the law changes, you can update your plan.
Yeah, that's great. Yasmin, I think we have come very close to the end. Today has been amazing. I think there's been absolutely lots of golden nuggets in there. And for anyone that's watching that's just jumped on, if you've missed the start, please go back and rewatch it. Obviously, this is going to be available on the Facebook in the Dentomology group. Where would we find you if someone needs to get in touch with you, Yasmin? What's the best way? I know you're obviously in our group, which is great, but how else can people find you?
Really, any of the ways of: 1, send me a message on the Facebook group. 2, send me an email, Yasmin with an E at clinlegal.com.au. Or 3, you can call me. So any of those ways are very popular for how people communicate with me, and I normally seek to return the reply within a day or right away. So yeah, please feel free. There was one thing that I didn't say at the beginning. If I just have 30 seconds, can I say it? when you asked me about the history and why I established Clin Legal, I forgot to mention that there was one specific event, and it's a really key one. So there was a doctor that I was working for in a dental practice that I was helping with his employment law stuff, and he had a dental assistant who was just sick and tired of working in the clinic and wanted to do admin stuff, but was needed in the clinic. And so she started to allege bullying. So she said, because I was asked to take a bin out, I've been bullied, because I had to have my lunch break at a separate time from the rest of the team because the practice wanted to make sure someone could answer phones and be available. I was bullied, and then she went on stress leave and put in a workers' comp claim. And so that's kind of the first painful experience that one of my clients had, when he was totally in the right but lost sleep and money over it. It was just so awful. And in the end, we actually issued a Fair Work complaint against her for her making these unlawful allegations. So I think I just wanted to share, it's something so small like that, like a junior employee alleging being bullied when she wasn't, going on workers' comp for stress, and the GP medical certificate gave her the diagnosis of bullying, but there wasn't even like a medical one. And so that was one small experience that inflicted pain. And I thought, well, I'm going to use this as an opportunity to make sure, you know, all of the people I work with are now protected from that happening again. So I just remembered, like when you asked me at the beginning, what was behind me establishing Clin Legal, I just want to share that, because I think people often have employees that might be in the practice that might push back on these tasks. And so, yeah, it is common. And yeah, that was the history, I suppose, or the story behind it.
I think a lot of people can relate at some level, one way or another, to a story probably very similar, different, but, you know, different spin, but similar sort of thing. Yeah, absolutely. I'm sure you're doing a lot of really great things for, the dental industry. It's fantastic.
Yeah, it looks just great. I love it. It's good to be involved, and working just with, you know, dental or ortho or medical just gives you that industry knowledge, I suppose. So yeah, it's fantastic.
Wonderful. Well, that's everything for today then. You have a lovely afternoon. Thank you so much for jumping on.
Yep, great to be involved, and shoot out if you have any other questions, and have a great day.
Wonderful.
Thanks.
Thank you.
Cheers.